And when the Human Rights Commission, which is a statutory body, not a constitutional body in India, which is a statutory body consisting of retired judges, they make a hold an inquiry and make a finding and make it clear that you compensate him because he has not done the correct thing. Then the right of that farmer or the marginal worker is vindicated. You may not get the money, but his right to criticize the government, his freedom of speech, his right of dissent, they are vindicated. And this one statutory body has upheld his right. He can go to court. So many times he cannot because he is poor. He can go to court and ask for this. Can you implement this? Court can implement this. So this is one very positive social and civil aspect. The next question is, your minister your Chief Justice joining the Council of Ministers, whether that impedes judicial independence. You see, till the other day, in England, where judicial independence is not questionable, is of the highest order, there the Lord Chancellor was a member of the cabinet, but that never stopped their judicial independence. The Lord Chancellor, the highest judicial office in England, your Lord Chancellor was a member of the cabinet. It was a political office. Even then, it did not hamper their judicial independence. It depends on the tradition of the system. I do not know what you can say. What is the extent of judicial independence in Bangladesh? I'm asking you.
Yeah,
tell us.
I can share that. In the highest court, our Supreme Court, maybe so you have heard that we have changed, a major change has taken place in our constitution by eliminating the provision of caretaker government. After any government, those who were in power for 5 years, and then when the parliament dissolved, there was an interim government. In the name of interim government, 3 months. Their duration was for 3 months, and this case was raised before the Supreme Court, the Appellate Division of Bangladesh, and then 9 eminent lawyers they argued this matter before the Supreme Court. 8 of them, they said there is a necessity to continue this provision, and only one of the lawyer and the Attorney General right now in our country, he said no, it should be abolished. Under the government, next election should be done. And then by ignoring all the 8 lawyers' advice, they were all amicus curiae in that particular case, appointed by the court. And the court came up with a verdict. The Chief Justice, after 18 months of the pronouncement of the judgment, this is such an important judgment, and only the ordering portion he uttered in the open court, and then when we finally found the judgment, full judgment after 18 months, the things has been changed.
This is what I told you.
Yeah.
The independence of the judiciary, the threat to the independence lies from within. The judge pronounces the operative part
in open court.
In open court, and after 18 months changes it.
Yeah.
Then the threat is from within.
That's what we are concerned.
That's unfortunate.
That's unfortunate.
The judges should be firm, and it should not take 18 months. And you cannot change it. What else? Set in open court.
That's
very unfortunate.
We are stunned by that judgment, and it has created such a chaos in our whole country. Such a political issue, burning issue, and then
that is unfortunate.
That is unfortunate. That's what I was
I think our friend from Lahore is trying to say something.
Sir, I'm not sure if I fully agree with your views regarding judiciary. I'm doubtful if Pakistani judiciary, especially and the legal community generally, have been helpful in upholding the rule of law, or for that matter, the judicial independence in Pakistan. I am not sure that Pakistani judiciary is independent at all, and lawyers too are not independent. And while we will be discussing in the next 1 hour or so what happened to the lawyers, so-called lawyers movement in Pakistan, let me briefly tell you, as Nasreen has just referred to one judgment from Bangladesh. Only a few weeks back, there was this case of an Ahmadi who was accused of certain offences under the Pakistan Penal Code, and he was not granted bail by the lower court. His case went to the High Court in Lahore, and while sitting in the court, the Honourable Judge granted bail, and he announced the decision. And the moment he announced the decision, the right-wing activists started shouting. And immediately afterwards, I mean, in a few seconds' time, he took the decision back. He dismissed the petition.
This is what I'm telling you. I have told her. When the threat is coming from within, why does it change? Does the judge change his decision?
Absolutely. So I think in Pakistan, specifically and generally,
the judge pronounces a decision on liberty of a person, and somebody shouting. Nobody can shout in court. If you are not agree, you agree by the decision, go to a higher court. Instead of shouting, that's contempt.
Yeah, I mean there are other incidents as well, and I can
that's unfortunate.
Refer to the Supreme Court decisions which clearly indicate that the judges are not acting independently. There has been not a single.
I don't want to say anything, but there are instances. Mr. Colin Gonzalez is sitting there. He is smiling. There are instances in the Indian Supreme Court also which should show that the judges are not acting very independently.
Absolutely.
There are instances. And I don't want to say that I was part of that court, but Mr. Gonzalez can say that. He can share with us. He has suffered some of those.
Here I have a question.
He has suffered some of those decisions. But sometimes it happens. What to do? That's unfortunate. Therefore, that is why I am telling you, the judge's judgments. I mean, judge is not above everything. His judgment should also be criticized. The judge's judgment, I tell you, you must be knowing that Jessica Lal's case in India, do you know?
Yes.
Are you aware of the judgment?
I'm not aware of the judgment. I haven't.
No, but what happened is, a gentleman wanted drinks beyond particular hour in a pub. The girl was serving, says it's not possible. You will go by some regulations. The only thing said it's not possible, you can't serve you. To that, the gentleman took out his revolver and shot at the girl from a point blank range. And he was tried. He happens to be highly connected. He was tried and got an acquittal. There was an uproar in this, in the country. The paper and everybody wrote the journalists did a wonderful job. There was retrial and he has been tried and convicted. This happened.
Yeah, the whole point is that I think we should not be complacent while analyzing the judiciary's role in social change.
Nothing is complacent. It's a constant fight.
Yeah,
I tell you what Pandit Nehru said. I'm not quoting anybody else. I'm just quoting his words. When Constitution came, it was the pledge of the then Congress Party that we must have land reforms. Land reform was introduced, that was challenged by the landlords. And the land reforms provisions were outlawed by court. Court said the provisions are otherwise. The government's effort of initiating land reforms was last fight. Within 18 months, Pandit Nehru moved an amendment of the Constitution, first amendment of the Constitution. And in doing so, he said the judges and the lawyers have paraloined the Constitution. You understand the word, meaning of the word paraloined? Stolen. This is what he said. The judges and the lawyers have paraloined the Constitution. He said this, the Prime Minister. He felt so anguished, deeply anguished and disturbed by the so-called judicial exercise of power. And then he got some portion of the Constitution amended, created a schedule particularly, and then brought this law. And that is how land reform was introduced in this country. Still the judges resisted, but initial introduction was strong. So judiciary is not a champion of the people's cause all the time, but slowly over the years it has become. If somebody writes about Indian judiciary and what happened during emergency, you know what happened? There's only the dissent which has saved us, the dissent of Khanna. You should read this. This is really a fascinating story. But it is constant pressure from the people which is sustained. Again we are losing that independence. That's what I am telling you. That the way the judiciary in India functioned in the late 70s and 80s is no longer functioning that way. I am sorry to say that. We need people like Prashant Bhushan, people like Kalin Zordar, people like you. Fight the people's cause. So what you are doing, you are actually advancing the cause of human justice, cause of human rights, which has been accepted in our Constitution. Constitutional provisions are very laudable, no doubt. I've showed you Article 30, Sub 2, Sub 3, that there is no movement. No pressure on the Parliament to make such a law. Then you have to each time go to Supreme Court. Is it possible? Any question?
Sir, though Article 38(3) has conferred the power on legislature to make the law 32(3), sorry, on the legislature to make a law with regard to conferring the power to any other court, in
power of Supreme Court,
power of Supreme Court to any other court. And legislature having not done that act, do you think this is the apt time that Supreme Court itself can go ahead and make some guidelines?